Joining me now, Stormy Daniels attorney Michael Avenatti. Great to have you with us tonight, sir.
Thanks for having me, Shannon. Really appreciate it.
You want to say anything more about those physical threats, whether they were reported to law enforcement, what you plan to do about them?
Not at this time, but I think when viewers tune in to the 60 Minutes interview this Sunday, they're going to learn in detail about those threats, and they're going to be able to measure for themselves the credibility of my client.
Well, it sounds like you and she want to continue proceeding as if the non-disclosure agreement is not valid. I know that you have filed a lawsuit to that effect. In the meantime, who is funding your services?
I'm basically doing it pro bono at this point. We've set up a GoFundMe page. It's actually not on the GoFundMe page. It's a crowd justice page in an effort to raise money. But other than that, no one.
Well, you know, a lot of folks have questions about why now, why this is coming to light, why if it happened 10 years ago or more when the president wasn't the president, why it's grabbing so many headlines. Let me ask you about this. On your own website, you say that while in college and later in law school, Michael worked at a political opposition research and media firm run by Rahm Emanuel, who later, of course, became White House chief of staff. Presently the mayor of Chicago. During his time there, Michael worked on over 150 campaigns in 42 states, including multiple gubernatorial and congressional campaigns, including Joe Biden's U.S. Senate campaign. Is any of this political in nature for you?
Absolutely not. That was 25 years ago, and it's laughable that people are pointing to that as the reason behind this. I haven't spoken to Rahm Emanuel since January 2nd or 3rd, 2007. Now, why do I know that? Because I ran into him in the Rio airport after coming back from a holiday for New Year's down in Brazil back in '07. I haven't emailed him, texted him, communicated with him. I haven't had any communication with Joe Biden or anyone else on the left. The idea that this is politically motivated is laughable. This is about a search for the truth. I don't care if you're on the right, the left, or in the center. You deserve to know the facts. That's what this is about, period.
Okay, your client, Ms. Clifford, her real name, we all refer to her as Stormy Daniels, but Stephanie Clifford, in the non-disclosure agreement, I know that there's a lot of language there talking about the fact that part of the deal that she apparently agreed to at the time, whether it's valid or not, as you now contest, it talks about a lot of tangible property. It talks about potential text messages, still images, all those kinds of things. And part of the deal was that she would make sure all of it was turned over to the relevant counsel. Or it was destroyed. Does she still now maintain any of those materials? Does she plan to go public with any of those?
I'm not going to answer that question. That's a question for her. But what I will say is this. There was never any deal because the parties to the deal did not execute the agreement. Your viewers know that if there's a written contract, if everybody doesn't sign it, there's no deal. And in this situation, everybody did not sign the deal. Donald Trump never signed the deal. And there was consideration that my client was to receive beyond the $130,000, consideration that only Donald Trump could provide. A release of claims, an agreement to stay away from her and her family. The list goes on and on. This deal will never be upheld in a court of law. There was never any deal.
Okay, a couple of things. You and I both know, we learned in the first year of law school, that there are contracts, and courts do this all the time, that uphold things that aren't fully signed. You know that happens. I know that happens. But let's point out the language here so that we can talk about that. In this deal that was signed October 28th, 2016, the first part of it says, this settlement agreement and mutual release is made and deemed effective as of 28th day of October 2016 by and between EC LLC, which is the company that Michael Cohen set up, and or David Dennison on the one part, grouping them together, and Peggy Peterson on the other parts. Now, I know that you've talked about that and or language, but it sounds like, you know, in the clause right after that saying on the one part that they were a pocket deal. Cohen signed this deal. So how does that not satisfy the fact that both sides, both parties of this agreement have signed it?
Well, first of all, under California law, and or is a conjunctive term. It's a plural term under the law. But it's even simpler than that. It's basic English. If, in fact, the intent of Mr. Cohen was that the agreement could be entered into either by EC LLC or Donald Trump, he inverted the names. He got it wrong.
But the word or is used.
No, but no, it's simple.
Used.
It is used, but that's not the reading of the English language. He inverted the names. If he wanted it to be that EC could enter into it without Donald Trump, EC needed to be the second name, not the first name. And I mean, it's simple English. And regardless, Section 8.6 of the agreement required all parties to sign, all parties. This
Okay.
agreement's going to be thrown out. It's full of holes. It's poorly drafted. It has all kinds of superfluous language. I don't know who drafted this in Mr. Cohen's office, but whoever did it did a terrible job and certainly did not serve Mr. Trump well.
You mentioned the issue of consideration, so let's talk about that. It details that you are to be paid, and then when all of the conditions are satisfied, ultimately the money would go to your client. It was wired to you. Did you write her a check?
No, it was not wired to me. This was her predecessor counsel, to be clear.
Okay.
My client was to receive $130,000 and a whole host of other consideration from Mr. Trump.
Did she
not
receive
Mr.
the money?
Cohen. She received the money, but she didn't get the rest of the consideration. It's like buying a house, a 4-bedroom house, but you only get 1 bedroom. That's not a deal.
What didn't she receive?
Well, she didn't get the release from Mr. Trump as provided for in the agreement. She didn't get the agreement by Mr. Trump to stay away from her and her family and not contact her.
So
she didn't get a whole host of other things.
When did he contact her or her family?
No, that's not the issue. The issue is the agreement, the binding agreement for him not to do so. That's the consideration. She didn't get the binding release in the agreement. Mr. Cohen could not bind Mr. Trump under the agreement. This is going to be thrown out. There was no agreement. It's just that clear.
Well, it's not that clear because we have the word "or" there, and talking about them being in one part. I know you filed in state court. The Trump folks are trying to move this to federal court. We'll see if that succeeds. We'll see if a judge likes your argument or if you get a different judge. I know this isn't the first time that you faced off against the president in court. You did so, at least with a settlement in 2006 with regard to The Apprentice. So you are at least experienced in facing him in another legal fight. So we'll watch this one and see how it proceeds. But we're glad to have you with us tonight. We'd love to have you back.
Thank you.
Thanks,
Appreciate it.
Michael.
Have a good night.